Hey, what's up, guys? Welcome to Lawsplaining the Interwebs. I am your host, Nick Rekieta of Rekieta Law, small law firm in central Minnesota. And today I have with me my trusty co-host, which is a glass of Maker's Mark. And I recommend that if you are a whiskey drinker, you pick up a glass and co-host yourself right with me. But I'm not encouraging that for anyone under the age of 21. You make your own decisions. All right, guys. So, if you don't know, we're going to just jump right into this. There's a guy on YouTube. His name is Jeremy. He runs the Quartering and Unsleeved media. I don't think he runs any other outlets, but I am not super familiar with him. He has been attacked at GenCon by a very furious princess unicorn by the name of Matt Loader, and that is how he would describe himself. I think he loves unicorns, and that is, and he works for Prettiest Princess. I don't know. These people are all strange to me. Okay, so the Quartering and Unsleeved media is a Magic the Gathering guy primarily, and he does a lot of YouTube content related to Magic the Gathering, goes to conventions, plays in tournaments, all that good stuff. He actually had a run-in with Wizards of the Coast a while back. I don't actually know how that ended up working out, but I was going to do a video on it, but by the time I was getting into it, other people had covered it, and so I kind of stepped back and let them take that one over, and I had other things to focus on. But now we've got this weird attack at GenCon. GenCon takes place in Indiana. It's kind of important because you just got to figure out what law is going to apply to all this stuff. So Indiana law is going to apply for most of the stuff going on here. But let me lay out the situation. Let's do our first section called Getting to Know Your Unarmed Assailant. This is Matt Loader. What am I doing here? Here we go. Right there. That is his LinkedIn profile. You can see he's got a handy receptacle for soy. He is the owner of Elm Street Games, which is a retail gaming shop. He teaches game design at Quinnipiac University. We'll see how long that lasts with an assault charge. Wait, I don't know if he's going to have an assault charge. He's probably going to have an assault charge. Is lead creative at Vice Games, runs the New Haven Game Makers Guild, organizes Fantasticon, does game industry consulting, fixing, and loves unicorns and weed. If you see him around, you should totally buy him a beer. So, I guess, maybe you should, maybe you shouldn't. That's up to you if you want to buy him a beer. But anyway, so what happens is Matt. Well, let's start with Jeremy. So Jeremy is at GenCon, big convention in Indianapolis, like I said, and between days, right? You have your convention hours during the day, and then there's some time at night for people to go home, sleep, shower, play games, pretend to talk to each other. All sorts of other things can happen. And then, they go back to the convention the next day in their new cosplay outfit or whatever. So between convention days, Jeremy is out at some bar, and the name of the bar eludes me, but it's not really important. The bar is not going to be a direct party to any lawsuit, probably. It's unlikely, in my opinion, that there would be some sort of vicarious liability to the bar. We're going to talk about vicarious liability in a little bit, but that's basically where you become liable for someone else's actions because you have some sort of duty of care that you have failed to provide. The bar probably doesn't have a duty to protect everybody around it unless they unreasonably don't protect someone. But this event happened very quickly. And it'd be hard to justify that sort of action based on the information I have. That could change. If it does, I'll tell you about it. But for now, just know he's at a bar. Jeremy is meeting people, talking to people, as he is probably doing a lot. This is a YouTube guy with over 100,000 subscribers, and he's in his element. He's in the gaming element. He's probably going to be seeing a lot of people who watch his channel or who have seen his face, and they're going to, say hi, shake hands, and all that stuff. All right. So he goes... he's talking to people. He gets like a tap on the shoulder or something. And a guy says, "Hey, are you Jeremy or the Quartering or Unsleeved Media," or whatever he says. I don't know. I wasn't there. I don't know what he said. But it doesn't matter. Jeremy turns around and says, "Yeah, man," holds out his hand to shake it. And then wham! Punched in the face. A whole bunch. And from what I can tell, maybe grabbed and held. This is kind of what I'm getting out of the reports, is that he was grabbed and held so that the punching could be done even more effectively. So that's what's going on here. This may look like a simple case, right? Simple case of punchery, but it's not so simple. Legal issues rarely are. But they get kind of complicated, because who all is responsible for this? And that's what this video is going to focus on. What happens now? And not all of you are going to be a popular YouTuber who is at an event. I may never be a popular YouTuber either, for all I know. Probably not. One day, the whiskey police will get me. But either way, not everybody's going to be a popular YouTuber at an event that gets attacked, but a lot of people who watch this video may get attacked at some point in their lives. And what do you do following that attack? And it really does matter, especially in these types of settings. So kick back and hang with me through some kind of complex legal issues. I'm going to go through them at a very high level. And this is something I need to make clear, because I got some of this feedback from the Diversity in Comics videos, usually from very respectable comic pros who are obviously all legal experts now, telling me about the chances that Diversity in Comics would have in court and how all this would fail and blah, 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 blah. Let me make something clear here. Having any amount of information and facts and stuff on your side does not guarantee you any sort of result in court, okay? But in court is not the only place that legal work happens. In court is just where the worst parts of legal work happens, where you have a contentious adversarial setting and you try and figure out someone tries to figure out facts. That's what a jury and a judge's job is to figure out the facts. And then once they decide on what the facts are, based on all the people telling them what the facts might be, once they decide what the facts are, they determine if the law applies. But having a bunch of information about what happened doesn't necessarily mean you go to court for it in any particular way, in one particular way or in multiple particular ways. There's a lot of other ways to use that information. You can use it for publicity. And if you notice, Diversity in Comics has used it very effectively for their publicity, for promoting their products, for being the group that does not advocate, like deplatforming and takes like their whole position is to take politics out of the entertainment medium and maybe just make a good story. And they're using the censorship that they received, the silencing from dopes like Mark Wade, stuff like that, to their advantage in promoting themselves and promoting their platform. That's one really effective way to use a bunch of legal conclusions. That's okay. There are other ways to use it, are to approach the other party or to approach people who are associated with the other party, not in we're going to silence you type of way, but in a let's resolve this type of way. Because some of the people, as you'll see in this video, might have some responsibility for what their little princess unicorn did. And that, with that responsibility might come some duty to make redress. And so if they're trying to make amends and make Jeremy whole for what happened, he might be able to leverage the information around this situation to get a monetary award through like a negotiated settlement. He may be able to use it to get access. He may be able to use it to collaborate with that company. A lot of different things can happen as a result of something like this. And so I don't want people to think that I'm just saying, he's going to go to court, he's going to win, and strippers and Lamborghinis are going to rain down from the sky on him, and life will be grand. That's not how it works. That's never how it works. Even if you can go to court and win, you don't always have anything more than a judgment. You don't know that the other person has the ability to pay or whatever. So don't take this in that way. I'm going to discuss the legal issues here and what the potential legal outcomes are. That doesn't mean that pursuing these legal outcomes is the best option. All right, so that disclaimer, way too long being stated. Let's jump into what happens. Did I mention this already, right? Jeremy's at a bar between convention days. Prettiest Matt, or whatever, this Matt Lauder guy comes up, says, "Hey, are you Jeremy?" Turns around, grabs him, starts punching him in the face. And then now we have what we in the business call battery. Battery. And battery is what it is called under Indiana criminal law as well. Some states will call it assault. It is battery in Indiana. And now that's on the criminal side. On the criminal side, it really just depends what the state statute labels it. Some states are going to call it assault or battery, or assault and battery. It doesn't really matter. Indiana calls it battery. Once you have a rude, offensive, unwanted touch. Rude and offensive are in the statute. But anyway, so once you have a rude or offensive or unwanted touch, you have committed a criminal battery against someone. This does not have to be an injury. In fact, it's a Class B misdemeanor, which is a very low-grade misdemeanor. And it just means that you, with rude or offensive intentions, went up and touched someone, and they did not want the touch. Okay, that could be any number of things. Once you cause bodily injury, however, any bodily injury, and to be clear what bodily injury is that is pain. Pain is bodily injury. If you punch someone, you almost undoubtedly have caused, or at least intended to cause, bodily injury. And once you have that intent to cause bodily injury, you are kicked up from a Class B to a Class A misdemeanor. Some states would call this like a gross misdemeanor. Typically, this is going to push your sentence towards like getting close to a year in jail being the maximum potential sentence. All right. So Class A misdemeanor is not something that you want to have. It would also likely prevent you from being able to own guns for the rest of your life. So not a good thing to have if you are a gun owner. I'm not so sure Matt Loader is a gun owner. But, well, I don't know. Maybe he's worried about the Nazis that he wants to punch and would own a gun. Not sure. All right. The next level of battery would be causing moderate bodily injury. That kicks it up to what's called a level 6 felony. It's going to be a low-level felony, probably talking 1 to 3 years in prison as a maximum sentence. A couple $1,000 fine. You may have to pay some restitution for something like a medical bill or something like that. But a level 6 felony involves moderate bodily injury. Now, there's states break down bodily injuries in different ways. I am not an expert in Indiana law, but I can tell you what I bet moderate bodily injury is. Bodily injury is going to be pain. Moderate bodily injury is probably going to be bruises and lacerations. So getting any sort of cut or any sort of bruise or lasting welt, that's going to be moderate bodily injury. Next, kicking up to a level 5 felony, which is probably going to carry something like 3 to 5 years in prison as a maximum sentence, something like that. And the fine goes up very quickly, probably somewhere in the neighborhood of 5 to 10 grand. That is going to be when you cause or intend to cause serious bodily injury. Serious bodily injury is going to be broken bones, or some sort of head injury. Typically, serious bodily injury is the part where if this went untreated, the person, like imagine it's Oregon Trail days, and the person were to sustain this injury, that they'd be at risk of dying. So, a broken bone, if left untreated, will, one, heal improperly and cause permanent disfigurement. That's definitely serious bodily injury. Two, it could get an infection and cause death. A head injury, like a concussion or something like that. Those can be very serious. They can cause death to people as well. They can cause memory loss that is permanent. Those sorts of things are serious bodily injuries. That's going to kick it up to a level 5 felony. Now, I have seen some images of Jeremy. It's hard to say what level of injury he has sustained. It will depend on what his doctors say. But, he's definitely sustained some sort of bodily injury, even if there are no lasting marks or cuts. He certainly felt pain. He was battered. So we're talking at least a Class A misdemeanor assault, possibly kicking up into a level 6 felony, and with a slim chance of being a level 5 felony. But I don't have his medical records. I don't know. But that's how they break down battery in Indiana. Okay, and remember, this is just the criminal side. The civil side is where the really complex stuff kicks in, so bear with me on this. I'm going to try and explain it as fast and plainly as possible. But it's complex. Now, allegedly, supported by both Jeremy and witnesses, Matt, the pretty princess unicorn, had also, and this is not very unicorn-like, if I might add. I think this is outside the scope of what unicorns would do, but he allegedly said something along the lines of, "I'm going to effing kill you," while he was striking Jeremy. And that could pose a problem for him as well. There is a statute against intimidation in Indiana. This is a threat, okay? This is when you're threatening someone. So, here we go. A person who communicates to a threat to another person with the intent, one, that the other person engage in conduct against the other person's will, two, that the other person be placed in fear of retaliation for a prior lawful act, or three, of causing a dwelling, building, or other structure or a vehicle to be evacuated or interfering with the occupancy, commits intimidation, a Class A misdemeanor. However, now this is where we get into trouble. The offense is a level 6 felony if A, the threat is to commit a forcible felony. Now, I'm going to kill you, effing kill you. That's a forcible felony, right? Like you're threatening to kill someone. That's a forcible felony. And then the person to whom threat is communicated as a law enforcement officer, as a witness, as an employee of a school, or as a witness in any pending criminal proceeding against the person making the threat, blah, blah, blah. The person has a prior unrelated conviction for an offense. This doesn't, these are all ors, okay? So, we just really need to focus on Section A. It's a level 6 felony if the threat is to commit a forcible felony. That is... Okay, let's see what a threat is under Indiana state law. Threat means an expression by words or action of an intention to 1. Unlawfully injure the person threatened or another person or damage property. 2. Unlawfully subject a person to physical confinement or restraint. 3. Commit a crime. 4. Unlawfully withhold official action or cause such withholding. 5. Unlawfully withhold testimony. Not important. 6. Expose the person to hatred, contempt, disgrace, or ridicule. 7. Falsely harm the credit or business reputation of the person. Or 8. Cause the evacuation of a dwelling, a building, or another structure or a vehicle. So we have it right in 1 and 3. Unlawfully injure the person threatened or another person or damage property. Or 3. Commit a crime. Killing someone, generally a crime, and unlawfully injuring someone is typically involved in walking up and punching them a whole bunch in the face. And saying I'm going to effing kill you is part of all that. So it's possible that he's got a level 6 felony here as well. This will all be up to the Indiana prosecutor and what they determine they have the ability to potentially prove beyond a reasonable doubt, okay? But the criminal case on this is pretty straightforward. So Jeremy, after being attacked, filed a police report, which is what you definitely want to do, and then he went to the hospital, which is another good thing to do. He's talked about some steps that he's going to take as soon as he gets home, and let's talk about those now. When he gets home, he's going to consult his personal doctor. If you go to an urgent care or an ER in Indianapolis, fine, but you want to definitely, if you're in a foreign city, you go back home, you talk to your own healthcare provider because they know your health history, and if there's something off, like if you have a head injury and you after a couple days, maybe you can't remember something or images are fuzzy, stuff like that, you're going to be able to tell your healthcare provider, who can check against your prior history with better accuracy than a doctor who's never met you and is just an ER or trauma doctor, okay? So you definitely want to talk to your own physician after at least a couple days and kind of assess what's been going on. Because if you have some lasting injury that didn't manifest right away because of shock or adrenaline or any number of other factors, you want to make sure that is documented. Okay, this is how you protect yourself in the upcoming civil lawsuit. And of course, your doctor can report any of these results to law enforcement, and it may be useful in the criminal term as well. And like it may kick it from bodily injury to moderate bodily injury or to serious bodily injury, right? Depending on what happened. So you definitely want to talk to your own doctor. Great move. The next move you need to talk to do is you got to talk to a therapist. Okay, now hear me out. The joke would be, yeah, you got attacked, get over it, suck it up. I mean, yeah, if there's a physical injury, whatever. But the reality is, if you're a person whose job it is, like Jeremy, to go around to conventions and things like that and meet people, and in the course of doing that, someone came up, surreptitiously introduces themselves to get your attention, and then attacks you, I would bet, pretty much any normal human is going to have some sort of negative reaction to that. It's going to last more than a day. The next person who comes up and taps him on the shoulder from behind, he's probably going to be anxious or apprehensive. He might not want to turn around. It could make him not want to go out and meet people. Post-traumatic stress is a real thing. It can be caused by all sorts of different things. Being attacked violently in public while you're away from home, this is a massively common cause of post-traumatic stress type situations or lasting mental injury, even if it's not clinically PTSD, causing anxiety or apprehension, people not wanting to go outside, people getting depressive thoughts that maybe, like other people hate them. These are real damaging things, especially to someone who's a semi-public or public persona, because Jeremy's job is to go to these conventions. That's how he generates revenue, and he goes to conventions, does coverage of them. And if he is impacted in doing that, it needs to be documented by a licensed, medical professional that's in the field of psychology or psychiatry or whatever. Go to a psychologist, okay? Go to a therapist, talk to them, because you need to do self-care or whatever little frilly word you want. It doesn't really matter. But two, in terms of your legal liability, you've got to know what kind of injuries you have to know if you should bring a claim against them. You have to know, maybe he'd go there and he's like, you know what, I think I'm going to have PTSD from this. And they talk to him, and over a couple sessions, they talk to him like going out to the store. Someone approaches him from behind. Is he feeling anxious or nervous? And he's like, no, I'm actually fine, because the person wasn't dressed like a unicorn or whatever. So they're okay. Well, maybe he doesn't have PTSD. And then, he wants to know, he would definitely want to know that as well, because if you're going to bring a claim and you're going to say that there's some infliction of emotional distress or something like that, which we'll talk about in a few minutes, you want to be able to support that, and you're going to need a medical professional's opinion. So you definitely call the police, go to the doctor. If you're away from home, you go to your home doctor when you get back. And then, of course, you go to a psychological professional or a therapist or counselor of some sort who can document any mental damages that may be taking place. All right. Next steps. One step that I don't think Jeremy did, and this is an optional step. If I were Jeremy's attorney, which I am not, clearly not, and I cannot give him legal advice in Indiana or any of that stuff. But if I were Jeremy's attorney, I would likely have discussed with him, if not outright advised him, to pursue an emergency restraining order during the convention. In my opinion, if he didn't do this, he dropped the ball. Guys, if you get attacked by someone at one of these conventions, whether you're a YouTuber or not, someone decides to punch you, you Nazi, whatever it is, go get a temporary restraining order. Talk to a lawyer if you can afford it. But if you can't afford it, there's often a self-help section on whatever state you're in's court website. Their Supreme Court website will typically have a set of documents, especially for something like a restraining order. And you can generally get it without notice to the other party. You can get it without really much court hearing. A lot of the times in Minnesota, for example, your fees are paid for by the court, your fees to the court. So there's no filing fee. There's no response fee for the other person. They want to make sure you're protected. And you can do this very, very quickly. You can get an order the same day, typically. And it's done a lot of times ex parte, which means the other party is not present. Because the nature of protecting you based on what happened is more important than like service and notice and all that. They can contest it later, but if you're at a short-term convention, you know the guy's going to be there the next day because he's got a booth, definitely file a restraining order. You don't want to have to deal with him. Have him thrown out of the convention. You can have the restraining order served on the convention staff. You can bring a local officer with you and have the guy removed from the convention or move far enough away. All of this stuff can be done very, very quickly, usually pretty cost effective. You should, I can't stress enough, have an attorney help you draft that motion because you need to lay out the factual basis for the court to determine that there's imminent danger to you from this person. Guys, if you're at a bar minding your own business and some dummy walks up and says, "Hey, Joe," and then Joe's your name or whatever, and they get your attention and then start punching you in the face, you have every reason and right to fear further damage and violence from this person. You don't know what they're going to do. Maybe next time it's a knife or a gun. You don't know their mental state. You don't know if they're off their unicorn meds. You don't know if they've eaten too many soybeans in the past hour. You don't know. Go get a restraining order. There's no shame in this type of stuff. And have the jackhole removed from the convention. Ruin his business for that day because he deserves to have it ruined if he's going to be assaulting people. All right? Can't be there. Gotta go. Your fault. That's a step that I don't think Jeremy took, that if I were his counsel, I probably would have at least had a very serious discussion with. But I don't know all of the facts, only what he said publicly. So, there's that. Next, when you get home, file a restraining order against the person in your state. This is a magical thing. I don't know where Jeremy lives. He's probably said it. You guys might know. I don't know. But in his own state, he can file a similar restraining order. He doesn't know if there's going to be a convention in his own state that this guy might attend. He needs to be in advance getting a restraining order against this person. Again, they'll often issue it ex parte. If it's in his state, the guy may not be able to attend to contest it. If he doesn't want to pay a lawyer in that state to contest it, you're going to get a restraining order. And it's going to be great. If that guy ever comes to your state, can't come bother you because he's got a restraining order against him. That restraining order would prevent him from owning guns, prevent him maybe from shooting you. If he approached him, in Jeremy's state, obviously that would be a crime in violation of the restraining order. But he should definitely talk to someone about something like that. Talk to an attorney in his own state. That'd be a very wise move to see if a restraining order in his own state would be in order. I think it would. He definitely has reasonable fear that if this guy were to enter his state at like a convention or anything else, that he could be attacked. Plus, he'd be able to present that restraining order to upcoming convention staff and say, look, this is a restraining order in my state, but it's because my state found these facts to be true. This jackhole came up and punched me in public for no reason, uninstigated by me. He's a danger to me, and I would prefer it if we could make some arrangements that he's not around anywhere near where I'm going to be. That's fine. And then you can, of course, provide that to police in other states and stuff like that. Restraining orders are typically only enforceable in the jurisdiction that they're given, but they can be influential and helpful in other jurisdictions as well. Okay? So, next. Now we get into the weird stuff. So Matt Lauder, again. Whoop. This little genius. Making friends since 1982, apparently. Owner of Elm City Games. Why is Matt Lauder at the convention? I believe Matt Lauder is at the convention for a couple reasons, and one of those reasons is as owner of Elm City Games. So I mentioned earlier, winning in court doesn't always get you Ferraris and strippers falling from the sky. Right? That's the problem with court, is when you win, you got a judgment, and then you get to enforce it. And that can be just a peachy, joyful experience. Especially if the person is like maybe broke, right? Then you can't get money out of a broke person. What's interesting, though, is this concept called vicarious liability. Now, I did some preliminary research, not extensive, on how Indiana applies vicarious liability in employment situations. This is basic agency law, all right? If you are the agent of a principal, then the principal can be liable for torts or personal injuries caused by you in the course of your duties for that principal. Now, Matt Lauder is the owner of Elm City Games, but as owner, he is also employee and representative of Elm City Games. All right? So if Matt Lauder, gosh, I got to get his stupid face off here. If Matt Lauder is the owner of Elm City Games, and if Matt Lauder is present at GenCon representing Elm City Games, and if Matt Lauder is in the course of his business meeting people, especially media people, in the promotion of materials relevant to Elm City Games, it is quite possible that he is, within the course of his duties, when he meets a media persona like Jeremy, who would be covering products that would be involved with Elm City Games, and when he punches him, that may create something called vicarious liability for Elm City Games. That means that if Jeremy is suing Matt Lauder for assault, Jeremy should also consider and talk with an attorney suing Elm City Games as well, because Elm City Games may be liable for the actions of their employee/CEO. Not a good thing to do. This is the whole point of having like an LLC or a corporation, right? Is some sort of entity. You separate yourself from the liability of the corporation or entity. That goes both ways. Like, not only are you separated from the acts that your business might do, so they can't come after your house for something that happens at your business, but your business is separated from your personal acts unless you do it in the course of conducting business. That's not a smart thing to do, Matt. That's actually really stupid. So, let's say Matt Lauder is a broke idiot. I don't know if he is. I'm not making that claim. Know nothing about him. Don't really care. Let's say he's a broke idiot. But let's say Elm City Games isn't broke, because Elm City Games has a bunch of inventory. Elm City Games may have credit. Elm City Games may have payroll. Elm City Games may have, money in the bank for purchasing future inventory. Elm City Games may have a lot of rare Magic cards that are worth anywhere from hundreds to thousands of dollars. I don't know. But Elm City Games probably has resources that Matt Loader doesn't. And piercing that corporate veil, and this is kind of used in a backward sense, but getting to Elm City Games' assets may be more valuable for someone like Jeremy than getting to Matt Loader's assets. Just saying. He should consider that. Because it kind of looks like Elm City Games sent Matt Loader to GenCon, especially if Matt Loader's planning on writing it off on his taxes like small business owners like to do with things like conventions, right? If he expensed that out, man, that sure looks like vicarious liability to me. To me. But who am I? I'm just a guy in Minnesota. Again, I'm not perfectly versed in Indiana case law, and Indiana case law is a little conflicting on vicarious liability when it comes to an intentional tort like assault, okay? Because oftentimes what will happen is a court will rule that the intentional assault goes outside the scope of duty for the principal-agent relationship, right? Like, Elm City Games probably didn't send Matt Loader to GenCon to punch Jeremy, right? Like, that probably didn't happen. But that's not the only, like, the problem is, this is how you construct the argument, at least in my opinion, is that what they did do is Elm City Games, Matt Loader being CEO probably had a lot to do with this decision, sent Matt Loader to represent Elm City Games to media personalities who would be covering this stuff to gin up interest and business in Elm City Games and its business endeavors. Jeremy is a member of that particular class of people, well, and customers, and he's also a member of that particular class of people that Elm City Games is directly interested in engaging. So Matt Loader, in reaching out to a customer, even between convention hours, and reaching out to a media personality, even between convention hours, still may be representing the company, Elm City Games. And if he is, they are potentially liable and potentially have a bigger asset pool than Matt Loader would. So that would probably merit some discovery. What you would typically do is you would name Elm City Games in your initial complaint. You would lay out the allegations as something that upon information and belief, we believe this. You would pursue an initial discovery. And in that initial discovery, you may find out that Matt Loader was not there representing Elm City Games, or that there's substantial evidence countering their vicarious liability. And then you amend your initial complaint and you remove them from there. That's fine. You can do that. That's kind of the process with how that works. And a lot of times that's why you see these complaints being amended 1, 2, 3, or 4 times, is that people are getting information that is changing who is involved in the lawsuit. And that's fine. That's part of the process. All right. They're not the only people who are potentially liable, right? Look at this. I'm going to duck. Expand City. What is this? Expand City, by all propaganda accounts I can find, was an extremely successful new board game presented at GenCon. Now, Expand City is produced by publisher Breaking Games. Interestingly, there's a designer by the name of Alex Cutler, and the other designer listed is someone by the name of Matt Fantastic. Now, you may recognize Matt Fantastic as Matt Loader, because they're the same person. It's not a surprise. Haha, gotcha. The question here becomes, is Matt Loader a representative of Breaking Games? Now, Breaking Games has said no, he is no way tied to us. We have nothing to do with him. I mean, pay attention to this. Obviously, this is the Geek Buddy analysis. They have the designer listed as Alex Cutler and Matt Fantastic. Don't know where they got that information, if it's completely fraudulent. I don't know. It honestly could be completely wrong. But it could not be completely wrong as well. Maybe they hired Matt Fantastic in a whatchamacallit, in a consulting sort of role. Maybe not. There's this interesting thing, though, that happened. Where is it? Where is it? Hold on. I got to pull up a Twitter thing. So this is from Breaking Games. All right. Whoa. Now, I don't know who tweeted this specifically. There's a quote here, though. Matt has nothing to do with any of her games. This is Alex Cutler, apparently. He's only very close friends with the creator of Expand City, Alex Cutler, and was at the con to help promote his friend's game. Sadly, this has gone awry for Breaking Games, as you know. Well, that's interesting. Because if Matt Fantastic is at the convention to promote the game, and if he's there at the behest of the designer or the company, the publisher, I shouldn't say the designer, but if he's there in an official capacity on behalf of the publisher of the game, then the publisher of the game suddenly may be in the same situation that Elm City Games is in, where suddenly they may be liable for the actions of their employee. And employee can be defined a lot of different ways. Typically, it involves some sort of wage and agreement. But, having a contract to represent them, even an oral contract, don't get confused by the term contract. Contract does not refer to a piece of paper. That is colloquial contract. That is not a legal contract. A legal contract is merely the agreement that exists. A piece of paper is a memorialization of the existing contract. Okay, so don't get confused by whether or not there's a piece of paper. Often there is not in these types of relationships. However, if Breaking Games requested Matt Loader to go to GenCon and promote this product, maybe at their table, they have potentially taken on liability because, again, Jeremy is the exact type of person they would want to be interacting with. He's a media personality who reviews gaming products. He is also a customer of gaming products and a convention attendee. All of these things are the people they would be hiring someone specifically to help them promote the game to contact. That's why you have someone there, right? Like, that's why you're at the convention in the first place. So, this would be another case where you include Breaking Games in your initial complaint. You request some discovery. That discovery typically involves things like emails, tweets, direct messages. All of those things become very relevant very quickly. Did these guys have an agreement to have Matt Loader promote their product? If they did, vicarious liability is on the table. If that's the case, Jeremy has now some tools in his tool belt, right? It doesn't mean he has a slam dunk lawsuit. Each of these extended liability cases to the companies is going to be harder. And the Breaking Games one is much harder than the store that Matt Loader, whatever his name is, that Unicorn Girl owns, right? Like, that one is much easier to prove a specific relationship, an agent-principal relationship, than it is with Breaking Games. But one might be there. And more importantly, it may be better for Breaking Games to collaborate or come up with some sort of alternative resolution than being included in a lawsuit that will look really bad for them when they've got potentially a co-designer of one of their games assaulting a customer and media personality. Not usually good press, especially for a small publisher of indie games. So that's where it is. Anyway, so these are the main issues. Now, there is another party involved here. Of course, the bar itself is somehow tangentially involved in this, but I don't think that vicarious liability expands to the bar, because The bar itself probably doesn't have any duty to protect. They likely don't have a relationship with Matt Loader. What they do potentially have, and this is important. One, they have, they could potentially have video evidence of the crime. And if that's the case, from what I understand, they have been hesitant to release anything. However, they could be compelled to release this by a subpoena in the event that a lawsuit is filed. And hopefully the Indianapolis police would be requesting or requiring them to turn over that information as well. But even if they don't, if that information exists, it can be subpoenaed. If that information is destroyed, that could complicate things very, very quickly. Now, the bar may be tempted to do something like destroying that evidence. If the bar happens to see this video, whatever bar you are, I don't care. I'm never going to your bar. Like the likelihood that I'll end up there is almost zero. Doesn't matter. If you happen to see this, don't destroy that video. That would be bad for you. That would make it look like you were complicit or an accomplice or somehow hooked up with Matt Loader. You should definitely talk to an attorney about how you handle the distribution of that video. But if you have not destroyed it at this point, I would not recommend doing that. I can't give you legal advice. Maybe you'll talk to an attorney in Indianapolis who says the exact opposite. I doubt it. Because that could be subpoenaed, and you refusing to turn that over could be a violation of a subpoena, which could be contempt of court. That could subject the bar to fines. It could subject the bar owners to jail time and stuff like that. It's just not a good idea. Maybe you should help solve crimes and potentially try and right wrongs in civil lawsuits as well with information that you may have. So, all right. But the bar probably not liable for any aspects of the crime. They just may be a holder of the evidence. According to Jeremy, there are several witness statements. That's good. He did say he was meeting some other people when Matt approached him and started hitting him. So all of those people would be witnesses. One thing you want to definitely do if you're ever in the situation, you want to get names, addresses, phone numbers of any witnesses. I would take pictures of them with my phone if they will consent to it. Obviously, try and be nice. But if someone witnesses a crime, say, you know what? It'd be great if I could just get your information so that when I contact my lawyer, he can contact you and get the information out of you and get a statement, for the future. If you can take a recorded statement at the time, wonderful. Do it. You've got a phone. Guys, you've got a phone. You can take video and audio recordings of people on your phone. They'll be time-stamped and date-stamped. You can have the person state their name and address on the recording. If they're willing to help you, take the help you can get. Use the tools that you have in your pocket. These are important things. If your phone gets broken in the scuffle, find a pen and paper. Or get them to video it and send it to you. We have all sorts of ways to communicate this stuff, and it can be very, very helpful and effective in building your case. But really, first step is call the police. Second step is get to a doctor. In the meanwhile, between those two, obviously, is when you'd probably interview any witnesses that are in the immediate area to just get some basic information or an initial statement from them. The police are going to try and do the same. And if you can provide the police the information for those people, like if they're not going to be around for whatever reason, do it. Get it. Get the information. Gather as much as you can. But assuming you do all that, right? Police, hospital. When you get home, your own personal doctor, you get a therapist because you've just been randomly attacked in public, and it's perfectly normal and okay for you to have some anxiety about that and to need that worked out. Then, of course, you got to pursue restraining orders. Like if you've got more convention days coming, restraining order. Get them thrown out of the convention that you have the right to be at, because they shouldn't be able to keep you away from something you have the right to do by intimidating you with physical violence. That's not how civilized society works. Get them out of there. Get them out of there. Then, of course, pursue the idea of a restraining order when you get home. All of this stuff costs time, money, and energy, and of course should always be done with the consultation of competent counsel. But I hope this video has kind of helped you understand the situation and the legal issues involved there. There's, according to the facts that we have, there's no justification for any of these attacks. Now, I do want to add that Matt Loader has asserted his innocence and said that all of this is fake news, or whatever, slanderous accusations, all that stuff. He has also deleted his Facebook and Twitter accounts. No idea why you would do that, but maybe he was just getting harassed by a bunch of people based on the fake accusations that definitely won't be backed up by video and eyewitness statements. But, you know, I don't know. Also, just so you know, deleting your Facebook and Twitter does not actually delete your Facebook and Twitter content when it comes to law enforcement. They can magically still access those files that Facebook and Twitter probably keep for at least 8 years, if not forever, because storage is cheap. And it doesn't take much to store texts. So if Matt Loader were to maybe say, yeah, I punched him, that was, you know, that would be stupid. Or if Matt Loader maybe asked people for information about where Jeremy was, and those people provided it to him, you know, those things might all still exist. So they don't just go away when you delete your accounts, dummy. But anyway, you know, all of those things. And for the record, for anybody listening, anybody at all, Facebook and Twitter do respond to subpoena requests drafted by an attorney and submitted following various subpoena procedures that are laid out clearly in their help sections. So you typically have to do them under state law. I believe Facebook is a California state law subpoena company. Twitter, I might be Delaware. I don't know off the top of my head. But it just says right there in the help sections of both of them how you subpoena something if you're a legal representative, and how law enforcement should proceed with criminal subpoenas as well. And they will respond. Believe me, they will respond, because they don't want to be a person who ignores a federal or a state subpoena. That's not in their interest. They do business in every state, and they probably can be hauled into most of them. So they do respond to those subpoena requests. Just in case anyone out there is listening, all of the messages that are, you know, between Matt Loader and whoever else he may have talked to, potentially subpoenaable. Consult an attorney in whatever state you're in, and maybe they can help you out with that. All right, guys. Thanks for watching. I hope you found this informative. I worked really hard to keep this under an hour because there's a lot of legal issues. I will be following up. Jeremy, if you happen to see this, I would love to interview you about this event and about the legal steps that you've taken so far. Certainly not high priority. Get your stuff in order, and in no way do I mean to jeopardize or complicate your legal representation in any way. But if you are able to come on and talk about how things are going, I would love to have you on the channel. Again, I did the same thing for Diversity in Comics. We can just talk about, you know, the legal issues involved, what you've gone through, and help people get to know you a little bit better. So, thanks for watching, guys. You can check me out on all sorts of social media down in the descriptions. If you like this video, if you think this is cool and useful, and if you think some of the people who are interested in the situation want to see it, please retweet it and pass it around and share it, or whatever media you use, send it around, and let's spread the word on what this looks like and what the legal aspects of it look like. Because I tell you, who probably doesn't know the legal aspects would be like random Magic the Gathering or video game people who are supporting the guy who punched someone in the face unprovoked. Like, they're probably not the best legal authorities. If any comic book professionals out there comment on this case, definitely do whatever the opposite of whatever they say, because those people, especially that Jamal Igle guy, like if he comments on it, yeah, is that his name? I don't even remember. That guy's just giant idiot anyway. So, but there you go, guys. There's my lawyerly take on the situation. Hope you all have a great night and very much enjoy this video. I will talk to you very soon. Thanks for watching.